In May 1816, the United States Congress gave permission for the Indiana Territory, as it existed at the time, to form a government and join the Union as a state, the state of Indiana. Wasting no time, in June 1816, 43 delegates representing Indiana's 13 counties met at Cordon to write a constitution for their new state. The building in which they met was Hoosier from top to bottom. The limestone was from local quarries. Poplar and walnut logs were cut from virgin forests for the ceiling and roof supports. The furniture was from Indiana makers. The convention was in session for 19 days. They elected Jonathan Jennings as the convention president. He was the leader of the anti-slavery majority at the convention and later became the state's first governor, running with the motto, "No slavery in Indiana."
I love the Indiana Constitution of 1816. I think it's the best thing ever written on the soil of Indiana. It's an astonishing document. And among the reasons I love it so is because of the provisions of the Northwest Ordinance on slavery. It said, "There shall be neither slavery nor involuntary servitude in this state." And then they added, "Nor shall any indenture of any Negro or mulatto hereafter made and executed out of the bound of this state be of any validity within the state." And then, to make certain that people fully understood, they added, "No alteration of this Constitution shall ever take place so as to introduce slavery or involuntary servitude in this state." Pretty clear.
The original 1816 Constitution is held under very tight security at the Indiana State Archives and Records. It only comes out once a year for public display, so it was an honor that it was brought out especially for us.
Eunice, I think you'll find this interesting.
Okay.
This is the 1816 Constitution of Indiana. It's the original Constitution. Article 11, Section 7 of the 1816 State Constitution deals with the issue of indentured servants and slaves. Your case, the Mary Clark case, was one of the first cases where the Supreme Court actually ruled on the meaning of this article and this section.
What is that?
This is where Jennings signs off. And then here's the signatures of all the delegates from across the state, or the territory at the time, that were involved with the Constitution.
So here we have the Northwest Ordinance and the new Indiana Constitution saying in very precise and clear language that slavery and involuntary servitude are illegal and unconstitutional. And yet, many people in the state continue to suffer under these conditions for years.
I think that the Constitution is in this way similar to many other laws. We pass a law, the legislature thinks this is a good thing, the court says something is constitutional, but making people follow the law is a whole different ball game. You can make a law, but somebody has to enforce it.
While the Constitution locked the door on slavery in Indiana, there were attempts to pry it back open.
The masters of slaves and indentured servants argued that the new Constitution was not retroactive. That is, slaves who were slaves before the Constitution went into effect were still slaves, and it only applied to indentured servant contracts made after 1816.
Absolutely were people who made that claim, and in fact that's one of the claims made by the person who had an indentured servitude contract with Mary Clark. He says this was authorized and signed before the Indiana Constitution actually comes into effect. Indiana wasn't alone in this respect, of course. There were plenty of places in the Northwest Territory, and indeed a fair number of places in the Northeast, where actual slavery persisted long after it was legally illegal. And I think that happened perhaps for two reasons. First, there was always a substantial minority of the population who thought these laws were unjust. And secondly, the sort of legal remedies that we take for granted today weren't available to everybody who was a slave or an indentured servant. They simply you didn't know any lawyers if you were in such a situation.
This was exactly the situation for Mary Bateman Clark. It was also the situation for a woman, a slave, Polly Strong, also of Vincennes. But they both would find attorneys who would help them, and they both would end up in the Indiana Supreme Court less than a year apart.